Hey legal team, welcome once again to Fitz in Law School. I'm Fitz, and today we're going to be talking about remembering Ruth Bader Ginsburg. Ruth Bader Ginsburg was an insanely successful and amazing Supreme Court justice. I'm sure a lot of you know that she was a pioneer for women's rights, and she was the second woman ever to be elected or ever to be appointed to the Supreme Court. But what I wanted to do is I wanted to dig a little bit deeper into the cases where she played a role and just kind of examine the amount of things that she has done for women in the United States, especially when it comes to their ability to be treated equally under the law. So, when you're trying to advance anyone's rights at all in the United States, there are several different ways to do it, but it's simply not enough to put within the Constitution that no one should be discriminated against based on their race or gender or anything like that. And so what her work really was changing the structural ways that rights are conveyed within the United States when it comes to gender discrimination. And primarily, she did that by essentially enforcing what's called the 14th Amendment of the United States. And within the 14th Amendment, it's the Equal Protection Clause. So skipping down to this particular part of the of the 14th Amendment, it says, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." End quote. So essentially what that means is that you have certain privileges and immunities that are conveyed to you either from the federal government or from the states. And if you have a right in one state and you travel to a different state, that state cannot say, all right, well, now you're in our state now, and so now you don't have those rights. So essentially, states can't really fight each other when it comes to the rights that they have conveyed to one member of their state, because you're a citizen not only of the United States, but you're also a citizen of that state in particular. So what I wanted to do today is I wanted to essentially take a look at the top cases that Ruth Bader Ginsburg had a part to play in. So what it's going to be is it's going to be the name of the case. All of these cases are Supreme Court cases. The name of the case, the year, the story behind the case, the court result, and then after that, the part that Ruth Bader Ginsburg played in this case. And I want you guys to take a gander at what exactly these laws are doing and how the discrimination, the sex-based discrimination, kind of played a part within the society. Because a lot of times what these things were was not what these laws were was not just kind of on its face discrimination. What it was is it was the state acknowledging or thinking that this is just the reality that we live in, and so we're going to codify essentially the sex discrimination that is inherent within the society. And in order to fight back against that societal-based discrimination, what Ruth Bader Ginsburg did is kind of attacked the way that those laws could be enforced. And a lot of the times, what she actually did is she tracked down, when she worked for the ACLU, she tracked down a man who was disadvantaged because their wife or their spouse or they were a widower or something, they were disadvantaged because of discrimination against women. And obviously she was presenting this in the 70s, and so that was during the Marshall Court and also the Burger Court a little bit later, and it was all men. And so because of that, she just saw that the court would be more receptive to seeing what the end results of this discrimination is, and then say, well, this discrimination just doesn't really make any sense because a lot of it is just based on kind of arbitrary stereotypes that don't really mean anything. And so it was a brilliant way to attack this kind of a discrimination. So the first case is Reed versus Reed in 1971. So the story behind this is that it was Sally and Cecil Reed, the son of these two people, died intestate. And so what intestate means is that when you die, if you don't have a will, then essentially you die intestate. That's what that means. So this guy died while his parents were separated, and then both of them applied to be the administrator of the estate, and that's kind of a general term for essentially whatever you have at the time of your death. And so an administrator can actually carry a lot of different privileges and a lot of different advantages when you're trying to essentially, like, maybe either get the estate for yourself or decide who gets what in the probate court. And so the state of Idaho had a law that essentially said, if the intestate estate is under $1,000, then what we're going to do is we're actually going to say, if there are more than two people who are applying, and it's a choice between a man or a woman, automatically it goes to the man. And so the goal of the law there was to reduce the number of hearings in probate court where they would need to decide. Essentially, it was just kind of a throwaway administrative law that was designed to speed up the process of a probate court. Again, this is a kind of it's the sort of benign discrimination that kind of resulted in maintaining the sex-based discrimination status quo that Ruth Bader Ginsburg really saw as part of a general problem of kind of the society really resisting it, resisting change to equality without actually necessarily being malevolent about it, which is kind of it's race-based discrimination, sex-based discrimination. That's kind of how societies fight back against it, is not necessarily by viciously pushing back, but by just saying, like this is just the law, or these are just little things, all that stuff. And so it's just a very interesting thing. When this went to the Supreme Court, the court said that this was arbitrary and unconstitutional. And for the first time, the 14th Amendment prohibited different treatment based on sex. So that was the first time that any kind of a 14th Equal Protection Clause argument was applied through the 14th Amendment to sex-based discrimination. And the court specifically said that a state can treat different classes of people differently. They can do that, but they cannot treat a class differently based on wholly unrelated criteria to the goal of the law. And so the goal of the law there was to reduce the amount of administrative costs and stuff that were related in probate court. And the court looked at that and said, there are other ways you can do this. Why do you have to discriminate against sex when there's 1,000 other ways to do this? And the connection to Ruth Bader Ginsburg is that she was a member of the ACLU at the time, and she wrote the brief with a few others, kind of arguing this case. And so she won that case, which is pretty cool. The next case we have is Frontera versus Richardson in 1973. So Frontera was a member of the Air Force, and she went and applied for benefits, housing benefits, for her husband, who is currently out of work. But the interesting thing is that the way that these benefits were conveyed to service members is that males actually got the benefits automatically for their wives, but females actually had to go through a ton of other steps in order to show that the husband was dependent upon the wife for income, for more than 50% of their income, and then they would get the benefits. But here, again, is another interesting thing that I want to highlight, is that this is how the sex-based discrimination was codified within the United States through the law. The reason why the state or the federal government was doing this is because they were accepting the reality that 99% of the time, back then anyway, males were the breadwinners. And they codified the economic reality into the law, which would then maintain that economic reality. So by maintaining that economic reality through the law, it essentially slowed down progress. And so that was another one of the reasons why Ruth Bader Ginsburg really tried to fight against that. And so the court ruled here that classifications based on sex, like race or national origin or anything like that, is inherently suspect and is thus subject to strict scrutiny in some cases. So I want to take a second to talk about scrutiny. All right, so scrutiny is the standard that the court adopts when they start to examine a law and determine whether or not it's constitutional or unconstitutional. And so scrutiny comes in kind of three, maybe four, but mostly three forms. It's rational basis, intermediate scrutiny, and strict scrutiny. There's also this thing called heightened scrutiny, which we can get to in a second, but that's kind of the fourth way, but kind of not, and it sits in between intermediate and strict scrutiny. But strict scrutiny essentially it frames it's the lens through which the court examines a law, and the higher it is, the more they kind of presume that it's unconstitutional, and the side arguing that it is constitutional has to prove that it is constitutional, as opposed it's kind of like innocent until proven guilty. You come in with a presumption of innocence in criminal cases. However, here it's kind of the opposite for a law, and they do that when they are examining certain laws that have been accused, either have been accused or inherently are race-based, national origin-based discrimination. And so this is sex-based discrimination. And what they said is that in some cases, when it's sex-based discrimination, now it's elevated to strict scrutiny. Or now they say, okay, we're going to presume from the beginning that it's unconstitutional. And so what this is that's and the way that they look at it are kind of three different ways. The first thing is that the state itself, either the federal government or the state, the interest that they're trying to forward, so the reason for the law, has to be compelling. The second one is that the law has to be necessary to achieve the purpose. So that essentially means there's no other option. This is the only way we can think of to forward this state interest. And the third one is that it has to be narrowly tailored. So narrowly tailored is this idea where if you put a law on the books, the people that will be affected by the law are essentially should be the only people that should be affected by the law. And so Ruth Bader Ginsburg here argued this before the Supreme Court, advocating for equal protection and strict scrutiny as an amicus curiae. So what that means is that's Latin for a friend of the court, and she essentially submitted an amicus curiae brief as part of the ACLU. Third case I want to talk about is Weinberger versus Westonfeld. Or Westonfeld, I think. And this was in 1975. So the story behind this, and this is another one of those times where Ruth Bader Ginsburg decided to pursue a certain client that would kind of fit the narrative that she was trying to do. So this is another one of those men was actually discriminated against, or females were discriminated against, and it was negatively affecting men to make it seem like a more sympathetic and more understandable client presented to the court. So Westonfeld was a father. And a couple years back, his wife had died. And so what he did is he actually went to the Social Security office and applied for Social Security benefits, like anyone should be able to do. However, what's interesting, though, is that the federal law said that Social Security benefits are only for a widow, not a widower. So that means that if your husband and your wife dies, then you don't get any of the Social Security benefits, even though you were paying into Social Security and the wife was paying into Social Security the entire time. So 100% of the population pays into Social Security, but only 50% of the population can reap the benefits of the Social Security. And so the court ruled that this was a violation of the Equal Protection Clause of the 14th Amendment, noting that women and men both pay into Social Security, but only half the population can cash in on some of those benefits. And Ruth Bader Ginsburg actually argued this case before the Supreme Court and won. And she used the fact that it was discriminating against men to say that discrimination based on sex really doesn't make any sense. The fifth case is Craig versus Boren in 1976. So Craig versus Boren is about an Oklahoma law allowing women. So there's this thing called lower alcohol beer, and it's like beer that's at 3% or something. And this was something that maybe still is, I'm not sure, but they was super popular in Oklahoma in the 70s. And essentially what this law said is Oklahoma was trying to reduce the number of tickets, drunk driving, motor accidents, all those kinds of things. And so they looked at the statistics of the people who get too intoxicated or drive drunk, and they saw that women were way less likely to be arrested for that charge than men were. Now, however, the point that was made in the case was that there's 1,000 different ways that stat could actually work out. What if women drive less, which they did, all those kinds of things. And so the law was saying that if you're a woman and you're 18, you can buy this beer. If you're a man, you still have to wait till you're 21 to buy the beer. So the result of this case was that the state relied on statistics of intoxication and tickets of arrest for drunken conduct, but that generalities about drinking habits of aggregated groups was not a good enough reason to go and make sort of a case like this. And so what this did is this actually established intermediate scrutiny for all gender-based discrimination. And so the state interest has to be, instead of strict scrutiny, the state interest just instead has to be genuine and important, not compelling. And the connection to Ruth Bader Ginsburg is that Ruth Bader Ginsburg at the ACLU advised plaintiff's attorney, submitted an amicus brief, and argued a bit of the case before the Supreme Court, and again, won. She argued 6 cases before the Supreme Court and won 5 of them. It's pretty impressive. The last case is United States versus Virginia in 1996. So this is actually when she was on the court. She was appointed and confirmed in 1993, and then she was on the court when this opinion was released, and she actually wrote the majority opinion here. So the story behind this case is that there was a place called the Virginia Military Institute, which is basically, it was just an undergrad school that also had sort of a military school aspect to it. And what they did is they were sued by the United States government because they were a state entity and they were taking federal funds for sex-based discrimination. And so what they did is they said, all right, you know what? We don't want to let women in to the military institute. So what we're going to do is we're going to create a separate institute only for women. And so it's going to be separate but equal, which is always kind of risky when you try to do that. But so the United States brought suit against the school saying that this was not okay. And so the result was that the court held that VMI's male-only admissions policy was unconstitutional because it failed to show exceedingly persuasive justification for VMI's gender-based admissions policy. The court also ruled that gender-based discrimination today should be elevated to heightened scrutiny. So heightened scrutiny is kind of in between strict scrutiny and intermediate scrutiny, but essentially this was Ruth Bader Ginsburg trying to push gender-based discrimination to be essentially legally on par with race-based discrimination to automatically get strict scrutiny. So Ruth Bader Ginsburg wrote the majority opinion, and she was reading it out in court, and a lot of commentators that I was reading about said that reading this announcement was kind of like an address to the public of the United States, and that it was plain spoken and forceful. And so it was just it seemed more like kind of a lecture about the importance of elevating sex-based discrimination to something that the society should fight back against, and that the law should reflect how this society is trying to fight back against that kind of discrimination. So in conclusion, it's just pretty interesting to think about Ruth Bader Ginsburg as someone who had such a great effect upon the legal system and women's ability to be treated the same way. I mean, it's pretty amazing to think about how women only got the right to vote in 1911. So that's 109 years ago? Like, that's it. It really was not that long ago. And our society has been slowly coming to grips with treating people equally ever since. But she was such an important part of this struggle. It's one thing to say someone's been fighting back against various systems for their entire life. However, it's kind of different when they were actually a part of the processes that was improving the system itself. You know, she wrote that opinion in United States versus Virginia, and she argued the cases before the Supreme Court when they decided to move along and progress women's rights within the United States. And it's a really, really inspiring thing. The United States and the world has lost a legal giant, and I really, really hope that whoever is nominated to replace her properly lives up to and somehow fills those tiny shoes that she had. Yeah, hoping for the best. Well, I will check all y'all later. Stay safe, wash your hands, and I'll see you next time. Bye.